This is a really common misconception. I have a will, therefore I don't need a probate. No, those two things are not equated. If you have a will, you may need a probate. A probate is the legal process to prove the will and to make sure that the will is in effect and the assets, your estate, pass under your will. Generally speaking, think of it this way. If you have a will, you will have a probate. Probate is a legal process, as I explained. But keep in mind that if you've worked with an estate planning and elder law attorney, the fact that you have a will doesn't necessarily mean that there will be a probate. The will is the safety net that covers what will happen with your assets. But oftentimes what we will do is we will draft the will that says where the assets go, but then we will set up the estate plan to avoid probate if probate is not going to be of any benefit to anybody. So for example, let's say that you have a house and you want your house to go to your child. We'll do a transfer on death deed on the house, no probate. You have a bank account, pay on death to your child, no probate. An IRA, 401k, life insurance, beneficiary designation to that person. So with an estate planning lawyer, you can set up your estate to avoid probate if that is what is best for you. But don't fall into this trap, this misconception that says, I have a will, now there's not going to be any probate. No, those things are not true. If you have a will, you may need a probate, you may not. And if you have any questions or you're confused about this, I would say seek out your attorney who prepared that will for you and ask these questions. I have a will, does that mean I'm going to probate or my estate's going to probate? You deserve to have an answer and a really good understanding of your estate plan, so I encourage you to ask those questions.